In the previous lesson, we introduced the next major topic for the law of trusts, this being the constitution of a trust. This video is going to talk and outline the methods of constitution. Now, the methods of constitution are going to be explored in more detail as time goes on, but we will explore and examine and essentially outline the methods of constitution in this video in more detail. So, we'll be talking about specifically as well the first method by which constitution of a trust can be achieved. This is through the simple transfer of legal title from the settlor or the testator to the trustee. Remember from the previous lesson that one of the issues in the case that we explored was that the transfer of legal title was incomplete because of the method by which title was transferred. It was not transferred in a valid way. It was transferred by way of a transfer of the certificate of shares rather than the prescribed corporate rule, which was the registration of the name of the trustee with the bank. So, as a result of which, no trust was created. The case of Richards and Delbridge, however, highlights the two main methods by which constitution of a trust may be satisfied, and it's here where we're going to begin. This is from 1874, and the facts of this case are relatively easy to understand. In this case, the settlor was the grandfather, and the beneficiary was his grandson, so it was a familial relationship. For all intents and purposes, it seems to be the case that the grandfather had intended to gift the property to his grandson. He did not seem to have intended to create a trust or to transfer property in that kind of way. It seemed to be an intention on the part of the grandfather to be a gift to the grandson. It was held that, as we know from the maxims of equity, that equity will not perfect an imperfect gift. So if there is an imperfect gift, i.e. the transfer of title is not perfected, then as a result of which equity will not step in as a way to perfect it. It will not be utilized as a method for recourse to perfect an imperfect gift. And so within the context of this case, the view that equity will not perfect an imperfect gift means that equity will create a trust instrument where there is a lack of evidence owing to the certainty of intention. In this case, the court also notes the two main methods by which the constitution of a trust may be established. According to the courts, a trust will be perfectly constituted when the settlor may either do such acts as amounts in law to the conveyance or assignment of the property, or the legal owner of the property may so deal with the property as to deprive himself of its beneficial ownership, and declare that he will hold it from that time forward on trust for the other person. This here outlines the two main methods by which the constitution of a trust may be established. This passage gives us two methods. The first of these methods is the transfer of legal title, which was an issue in the previous example from the previous lesson, i.e. The conveyance of property. And so when we think about the transfer of legal title, we are going to have to look at the ordinary law of personal property, as well as some law related to intellectual property, or even law relating to land law, conveyancing through the process of transferring a property in land. These are the first methods by which a constitution can be established for the trust. The trust's constitution can be made, the transfer of legal title. The second method is through a trustee making a self-declaration that the property will be held on trust for the beneficiary. So these are the two ways in which this will take place. Now, what we're going to do is essentially explore in more detail the first of these in the next lesson, the transfer of legal title, the conveyance of the property. And then in the lesson after that, we will talk in more detail about what is required for there to be a self-declaration and for the property to be held on trust for the beneficiary as being declared by the settlor or the testator.